Also, thank you for coming today, and hopefully this will be information that you'll find helpful for each of you. For some of you, this will be a refresher, having already established your estate plan. But for those who have not, this will provide you hopefully with information to encourage you to look into preparing your own estate plan. Today we will be providing you with information, tools, and materials that will assist you in managing your and your family's personal and financial affairs. I am collectively referring to this process as estate planning. Maybe that's a misnomer, but it encompasses a lot of things. One of the things that I will not be talking about today is giving legal advice or estate taxes. That's a whole different issue, which we're not going to be addressing. I want to talk about basically 5 different categories or subjects. The first is the importance of having legal counsel. The second is ways to effectively organize and manage your estate planning documents and your related documents. The third are what documents are essential for an effective planning. The fourth is what these documents can and cannot do. And finally, how to use these documents. Jesus tells us in the Bible that God provides for all of us. And in doing that, he has given us the intellect and the ability to care for ourselves and our loved ones. It also says that we have free will, which means some of you will do it and some of you won't. But the important thing is to realize that this is a tremendous area that needs our attention. Financial and healthcare planning involves providing for ourselves and our loved ones, in particular our spouses, our children, and our parents. Don't forget the parents. It's also important to remember that not only do we need to be prepared for our personal needs, but make sure our parents and children are properly well cared for. Over my 40 years plus of practicing estate planning and trust law, I've represented thousands of families in the handling of their affairs and the management of their estates and trust. I have witnessed the good, the bad, and the ugly. And the ugly is ugly. And this is what estate planning can avoid. And usually the ugly comes in when there's no estate planning. The ugly also comes in when we have dysfunctional families, which unfortunately there are dysfunctional families out there. And that creates enormous problems because people will say like, oh, I've done my estate planning. I said, well, what have you done? He says, I put my children on as the beneficiaries of my house. So when I die, they get the house. I said, well, that sounds wonderful, but that takes care of when you die. But what about if you become incompetent and we have to sell the house or we have to mortgage the house or we have to do something with the house for your support and care? Who's going to do that? I don't know. Well, unfortunately, his 3 children were dysfunctional. They did not relate to one another. They had different objectives. And for them to come together and agree on who was going to take care of Dad and how the money was going to be spent was not going to happen. And furthermore, of course, when he dies, then you have the problem of, okay, now we have 3 individuals who have different motives as to what's going to happen to the house. One says, I don't want to sell it. The other one says, I want to sell it. The other one says, I need money today. Let's sell it today. How does that all get worked out? Well, guess where you end up? In court. Everybody has an attorney. Everybody incurs thousands and thousands of legal fees, and eventually something happens. But the point is that can all be avoided through estate planning. We have a lot of time, as Scott said, at the end of the presentation for questions. And at the end of the day, we're going to have questions as well. Hopefully, we'll be able to address all of those questions. So let's get started with the importance of having legal counsel. I realize when I say that, dollar signs sort of pop up. But the importance of having legal counsel can't be overstated. Because this is not an attorney you see once and never see again. This person is going to become your family lawyer. And by that I mean they're going to be with you throughout your life. I had clients that belonged to my former partners. The firm was founded in '43, and so I took them over. My daughter, who's now a partner in the firm, she has my clients. Basically, we've had 2, 3, sometimes 4 generations of family members within the firm whose estates we handle. And this is important because you can pick up the phone at any time and call your family lawyer and say, we've had this happen, or this is happening, and you can make whatever plans need to be adjusted for that event. Because throughout your life, things will happen. I remember when Patty and I did our estate plan, we thought, well, my parents were very young at the time. They loved the grandkids. They had a good relationship with the grandkids. We said, okay, we'll make them the custodians of the kids if something happens to us. But as they got older and the kids got older, we realized that was not a good plan. So we changed it to a family that we were very close to, who was in the church. But that turned out not to be such a good plan either, because our daughter became the boyfriend of their son. And that might create some problems. Well, we decided to bite the bullet and take that and just see what would happen. Fortunately, everybody's okay, and that never came to pass. But things do happen that cause you to change your estate plan. So it's important to have this relationship. Also of importance is the fact that you want to be in a position of not divulging your estate plan to usually your beneficiaries and children. That's not a good idea for a number of reasons, some of which things change. One day you may have a child that you want to make trustee, the next day may be another. One day you have a child you may want to give more to, next day might be different. So basically having your attorney available is all you have to do is tell your beneficiaries, if anything happens to mom or I, contact our attorney. Here's his name, here's his phone number. He will then know what to do, and he will advise you. This is good because of 2 reasons. One, not only does he have either the originals or copies of your estate plan, but he also is in a position to provide them with direction. And you'd be surprised at the number of people that when there's a death don't seek out direction. They just sort of start acting. And that can turn out disastrous sometimes because they might be doing the wrong thing, not realizing it. So it's important to have this relationship with your attorney. And I suggest that you have an attorney too, because we all have particular needs. What I say today may have no relevance to what your family dynamics are, or it may. So it's important to have somebody on board that can address what is needed for your particular family. So keep in mind that every family has its own unique dynamics, and so, that some of my remarks may pertain to you, but if they don't, just put that aside and focus on the ones that do. So let's move on to the ways to effectively organize and manage your documents. This is really an important aspect of estate planning. It doesn't do any good, really. Well, it does some good, but it doesn't do a lot of good if you do not have the documents which set forth your estate plan readily available to your children or your heirs or your beneficiaries, your agents, whatever the situation might be. I can't tell you over the years the number of times I've spent literally hundreds of hours in people's homes, going through their file cabinets, going through boxes, going through their garage. This is especially challenging when you have a hoarder. I've actually had houses where I filled up 3 of those giant trash bins full of stuff just to get in to see where there might be documents. And you can't leave any stone unturned. And of course, at the hourly rates of attorneys, which I don't know what they are today, but they're probably $450 to $550 an hour, that can get very, very costly. So it's important that you have organized your documents in a place where you can simply say to your spouse, and this pertains to spouses too, because sometimes only one spouse is aware of the financial dealings, if you will, of the family. But this will provide one place where they can go and see what is in the estate, where it is, and what the estate plan is. I like notebooks. I've always been a notebook person, as my wife will tell you. We have notebooks on all our travels. We have notebooks on various things, but we also have 2 notebooks that are very important. One is the notebook that has all of our estate planning documents in it. That's this notebook. And in this notebook, it has our trust, our wills. These are copies of our trust, our wills, our powers of attorney, our directives to physicians, and that's basically the estate planning documents I'm going to be talking about today. I leave my original documents, they're now with the firm, in the office, in a safe, fireproof safe, in a vaulted room, which our office is got a very large vaulted room, obviously, because we have thousands of trusts and wills. And I do that, and as a practitioner, I always did that, because I found too many couples would lose their documents, or couldn't find their documents, or their kids couldn't find their documents. And losing an original trust can create all kinds of problems. Again, it depends upon the family. If everybody's copacetic, usually it's not a problem. We can go with a copy. But all you have to have is one spouse, usually a second spouse, one child, usually a child from another marriage, that contests the trust. And then you find yourself in court with expensive litigation. That doesn't happen when the attorney has the original in a safe. It never gets lost. The other folder that we have is the one that contains all of our assets, how they're titled, where they're located, and cards from various brokers and banks. This allows Patty, or our executor, to immediately go in and see all of our assets. Copy of our deed is in here. Copy of insurance policies, if you have them, is in here. Their copies are in here, not the originals. The originals of these documents are usually in a safe, or you don't need an original of a bank statement. But the importance of this is that for her, especially, since I usually manage most of the financial affairs, everything is here, and she can refer to it, and then she can meet with the attorney, which happens to be our daughter, and the successor trustees, which also is our daughter and son, they have the ability to pick this up and find everything and know where everything is. I can't tell you the importance of that and the tens of thousands of dollars that you can incur if you do not have something like this in place. I had one estate where I thought I had found everything. It was the joy of back in the days when, you remember, we used to have savings and loans? And back then they had $100,000 FDIC protection. So all my little clients would go to all of these different savings and loans and set up an account. And I used to call Friday cookie and coffee day, because on Fridays they would go visit all of their monies and all their different savings and loans because they provided cookies and coffee. And of course, when you have a CD, when you have a bank account, most of them were CDs. When you have a bank account, you have to have an interest checking account because they wanted the interest. They just didn't want to cash out the CD. So all the interest flowed into their checking account. So not only did we have a bank account and a checking account, I had one lady, 12 institutions. And so when she passed away, guess what? We had no idea where anything was because she didn't provide that. And going through her stuff, I saw all these little, and when they went on Friday, they just didn't have cookies and tea. They got their passbooks stamped. And they wrote in what the interest was. And so I found all of these things. And of course, by the time she died, none of these places existed anymore. So then the challenge was to say, okay, who took over Great Western Savings and Loan? And who took over all of these various institutions that no longer exist? Well, it was a monumental task. And I thought I had gotten them all. 2 years later, I get a notice from the state of California, Mrs. So-and-so has $100,000 at such and such an institution. Actually, it's an institution I never heard of. And as a result, I had to then open up a proceeding to get that additional $100,000. But these are just examples of ways that things can become very, very complicated. And of course, my first line of doing exploring of what the assets is the tax return, assuming they've done a tax return. And I've had clients that haven't done tax returns for 5, 10 years when they should have. That presents other problems. But in looking at the tax return, hopefully you will see listed all of the places where money is coming from, which will allow you to find out where those assets are. So I can't, again, over-exemplify the need to have your documents in one place. Now, at the end of today's program, I'm going to give you a handout. It appeared in the Wall Street Journal a number of years ago. It's called 25 Documents that you need before you die. And basically, this is an article that talks about what documents you should have in your estate planning documents as well as your backup documents. I apologize for the small print in the article. That's how it was published in the Wall Street Journal, so that's how we get it. But I think it's an article that's well worth reading and keeping. Okay. Again, for those of you that are caring for your parents, it becomes important to know where the assets are. But even doing that, you'll be surprised. I used to take young associates on me with what I called house hunts to show them where people like to hide things. Because I have found tens of thousands of dollars in freezers. I've found $30,000 in a fake oatmeal box where the bottom came off, oatmeal on top, and the bottom was thousands of dollars. I found one client who died and hid $25,000 worth of traveler's checks of all things. He thought they were a good investment, which, by the way, they're not. He hid them underneath his bed, just in his name alone. And then I found he also hid in his closet gold and silver and coins. None of this was known to anybody. And all of a sudden, instead of having a relatively small estate, we had a relatively large estate because of the gold. I've had clients that inherited money from their parents in the form of a gold certificate in Switzerland. They thought nothing about it. Every year they got maybe a statement. Well, it turned out that this one woman who came to me, when she suddenly realized her gold was worth $5 million, and she had to get it out of Switzerland, and she hadn't reported on her tax returns for the last 20 years. And not that she owed any money, but there's a little box on your tax return that says, do you have any foreign accounts? You know this little box? And basically all you have to do is check it and say yes or no. Of course, if you say yes, then you have to identify it. But by not checking that box, it's a $10,000 penalty. And of course, she had $10,000 penalties for years as a result. Well, fortunate for her and for us as her attorneys, that year, the IRS had an exemption or a waiver of penalties if you came in and fessed up. And so we came in and we fessed up. They waived all the penalties. The next adventure was to go to Switzerland, which I talked them out of my having to go, but to go to Switzerland to get the gold. Well, actually what we did was we had to go transferred from there to New York and then New York to San Diego. But this woman was sitting on millions and millions of dollars of gold and basically had no idea. There was nothing in the estate plan that would alert her to this, and she really had no way of following up. So it's extremely important to have these documents in order to allow your executor, which we'll talk about, your agent, which we'll talk about, your spouse, which we'll talk about, know where and what your assets are. So what documents are essential for effective estate planning? Perhaps the first question you might have is, before I discuss this, is why do I need an estate plan? Well, I have thousands of examples, but I'll just pick out a few that I thought might be helpful to you to see what drastic results can happen. A number of years ago, I had a young couple, 2 small children. Their estate was about $3 million. He was very successful. They decided to go to New York to celebrate their honeymoon. Get on the plane after dropping the kids off with in-laws, go to New York, and proceed to get in a traffic accident, and both were killed. No will, no trust, no nothing. They left 2 little children and a family that was divided on who should have custody of these children. They also had no one to handle their financial affairs. So as a result, guess what? We had protracted litigation between both sides of the family over who gets custody of the children, who gets to control the finances. If that wasn't bad enough, you have to realize that in California, you're an adult when you're 18, which is usually about your senior year in high school. Both of these children became millionaires when they were in high school, which is not a good thing. I can tell you from experience that's not a good thing. And it's all because there was no estate planning involved. So that's one example. Another one was a client. He wasn't a client Actually, it was some distant neighbors that were clients because they found him and he'd passed. He had no trust, no will, and he had several $1 million as well. But he had no heirs. That's the big thing. Nobody could step up and convince a court that they should be appointed as the administrator of a state, except for the government. So the state of California, County of San Diego, became his administrator. Now, administrator is the same thing as an executor, but executors are set forth in your will. Administrators are appointed by the court. When you're a court administrator, you do the exact same thing an executor does, except you do it with court approval and subject to them giving that approval. So what happened was, because he had no heirs, guess where his several $1 million went? State of California. It all escheated, as we call it, to the state of California. Again, if he just had a will saying, I want my money to go to charity or to friends or neighbors, or whatever, that would have all been avoided. And my final example is with regard to a durable power of attorney for health care, which we're going to talk about. This is a young man who was caring for his terminally ill mother at home. She wanted nothing to do with doctors. No doctors at all. Don't call the doctors. Don't call the paramedics. And when she became critically ill and was actually dying, he wanted to call the paramedics, and she insisted, no, you don't. So he didn't. Well, she died, and guess what happened? The San Diego District Attorney's Office indicted him for elder abuse, and he was convicted and sent to jail for 6 months. There was no power of attorney giving him authority to make these medical life-determining situations. There was nothing saying that these were her wishes. There were no witnesses that could say that this was her wishes. And so as a result, they found him elder abuse for her care, or lack thereof. And so he ended up spending 6 months. Now, there's a kicker to this, and that is there's a California law that says if you commit elder abuse and you're found guilty of it, you cannot inherit. So you're cut off as a beneficiary. And he was the only beneficiary. That's how I got involved in the case, representing him on that issue, which actually we got a successful result for him, but that's another matter. But the point is, he did spend 6 months in jail, and he was severely traumatized by this whole thing. So it is important for these documents to be in place to deal with this. And a lot of us think, well, I took care of all my needs financially. And you're thinking of when I die. Dying is easy. I mean, when you die, you're dead. So I can deal with that really simply. But if you're alive and you don't have in place documents to handle your affairs, then we have a problem. Because the question is, who does that? And if you don't have any documents saying who does that, then basically we have to turn to the courts. In California, it's interesting. Probate planning and estate planning is all statutory. And it's called a court of equity. A court of equity means they don't have to follow the law. A court of equity means they have to do equity. So the judge has a lot of power, and that's fortunate because many times judges did things for my clients that were not according to law, but they were equity. And that's important because if that didn't happen, there would have been some dire consequences. So we want to be sure that when we're dealing with these documents, that we understand what they can and can't do. As I say, a lot of people find it simple to deal with, well, when I die, this is what happens. But they have a hard time thinking about becoming incompetent. That's because most of us don't think we're going to become incompetent, and so we just sort of put it out of our minds, so to speak. But it can happen and does happen. And a lot of people don't understand when you're incompetent, what does that mean? Incompetent does not mean that you're permanently incapable of handling your affairs. Incompetency is defined basically as either the permanent or temporary inability to handle your financial affairs or your personal affairs, or both. So I've had clients that have become incompetent simply because they went into the hospital for a procedure which kept them in the hospital for weeks or sometimes months. During that entire time, they were physically unable to handle their affairs. They are defined as being incompetent. So what happens when your loved one's in the hospital and basically they're incompetent and you have to sign a tax return? If you do not have something in place, a mechanism in place, it becomes a very difficult thing. Or your spouse has a debt or liability. And have you ever tried to call a company and say, I'm calling about my husband's credit card? What's the first thing they say? and we can't talk to you, we've got to talk to us. Or they might say, do you have a power of attorney? And if you don't have that, they won't talk to you. Well, that's exactly what happens when you become incompetent. Nobody can handle your affairs unless they have authority. The only way they can have authority is basically through a power of attorney for asset management, which we'll talk about. Now, when you talk about a husband and wife, that's sort of a different situation. A lot of time, institutions will sort of bend the rules to accommodate a spouse if you can convince them you're the spouse and you're not the ex-wife or somebody else. But again, a power of attorney would solve those problems. So don't overlook the incompetency issue. It is extremely important. That document is almost more important than the other documents from the standpoint of the situation where you might become incompetent. Because one of the things you have to understand is with these documents, powers of attorney, and it's amazing, I've had banks ask for powers of attorney after a person has died, and I said, well, you do realize that powers of attorney end when the person dies. You can't have an agent when you're dead. And they go, oh. Well, then I need a court order. I said, no, this is a trust. You don't need a court order. But powers of attorney are something that are in effect while you're alive. Once you die, they don't exist. There's one exception which many people don't understand or realize. The power of attorney for health care has in it a provision of what to do with your remains. And so as a result, the person who is the agent for the power of attorney for health care is the one that gets the body. And they can do with it whatever they want, as long as it's within the confines of the power of attorney for health care. This is important when you have a situation where you have one child that says cremation, one child that says burial. And we have this giant fight over who's going to do what. And you get to, having gone this many, many times to a funeral home, and the first thing they're going to ask is, who has authority to take control of the body? Now, for a husband and wife, again, they're a little bit more lenient in this area. But anybody else, they want to see a power of attorney for health care that specifies that you have the authority to do something with the body, especially if you want to cremate it. They get really anxious because once somebody's cremated, you can't uncremate them. So they get really touchy when it comes to cremations. But again, if you have in your power of attorney for health care that you want to be cremated, and better yet, you've paid for it and arranged it, then there is really no problem with regard to those issues. So keep in mind the importance of those powers of attorney. There's basically four groups of documents that I'm going to talk about that are within estate planning. And I say possible because some of these you may or may not use. Like, for example, with the power of attorney for asset management. That generally is what we call a springing power. It springs into effect when you become incompetent. But as we get older, I recommend to my clients we switch that over from a springing power to a general power. And the difference is that with a general power, you can immediately take whatever action you want on behalf of the individual. We don't like having that out there when somebody is younger, but as it becomes more and more apparent that they're not able to handle their affairs all that well, or that the inevitable is coming, we recommend this general power of attorney because with the springing power, I have to take the springing power to the bank or to whoever and say, okay, here's a letter from 6 doctors that say so-and-so is incompetent, because then it won't spring into effect. And so then they have to decide, well, okay, that's good, or no, we don't like it, we want to get our own opinion, whatever. So it's important that you have in place a power of attorney for health care and one for asset management to avoid these kinds of problems. One of the things I want to talk about at this point, because it applies to all the documents I'm talking about, and that is liability. A lot of people don't understand the liability that a trustee takes on, or that an agent takes on, or that an executor takes on. This liability is set out in the codes. There are literally hundreds and hundreds of things you're required to do as an executor, agent, or a trustee. Some of which, if you don't do, you can be held personally liable. I had a case where a young man was a partner in a bunch of businesses, and his partner named him as his backup trustee. So when he died, he managed the trust because the children were minors, and he kept all of the investments in the same risky adventures that he and his partner were involved with over the years. One by one, they failed. Well, by the time the children were old enough to get their inheritance, they were all gone. They lost them all. Children, I guess it was me, sued him for breach of fiduciary duty, and he was found guilty in order to reimburse the estate for $375,000, which is what he lost. And that is a non-dischargeable debt. You cannot get it discharged in bankruptcy. So he had to reimburse these kids. Well, $370,000 was a lot of money then. It's not so much now. But the point is that because he breached his fiduciary duties, which is to immediately liquidate the estate upon death, he subjected himself to these liabilities. So it's important to understand the liability. And so when somebody comes to you and says, will you be my trustee? Understand, you are taking on a tremendous liability. My first response would be, let me check with my attorney. Okay? You don't have to be nasty, just let me check with my attorney, and then your attorney can tell you, is this a good idea or a bad idea? Because sometimes, the answer should be no. But if it is yes, that's great, but they need to understand what they're doing. And I'm going to talk a little bit about selection of your beneficiary, your trustees, and your agents, and your executor, because it involves all four of these documents we're going to be talking about. Many people think, well, the only person I can name as my executor is somebody that basically knows a lot about business or about finance, about asset management. Same thing with the power of attorney for health care, with asset management, and with basically your trust. That's not true. What you need is a person who is responsible, who is willing to bring in professionals to assist them in the administration of the trust. So many times I would meet with a trustee who is 2 months or 3 months out. They've done all these things, and they've realized they're way over their head, and they come in, and I explain to them, well, the trust pays for the attorney. The trust pays for the accountant. I mean, it's like you're saying, okay, well, I'm going to prepare the final, the tax returns for the previous year of this individual. I'm going to prepare for the trust tax returns. I'm going to do that all on my own. Well, that's ludicrous. That's not going to happen. You're going to have to hire an accountant. And the same thing with regard to handling other assets and transferring of assets. I'm going to transfer the house from such and such to such and such without the advice of legal counsel. That's not going to happen either. So it's important to understand that in those situations, you have to have an individual who's willing to do that. A lot of times they would say to me, but that costs money. And I'm trying to save the money for the beneficiaries. Well, you might be saving money for the beneficiaries, but it's going to come out of your pocket if you commit malfeasance. So it's one of those things where it is important to keep in mind what you do when you select your trustee. Now, your trustee for your health care, that's a totally different person. That is a person you want who is willing to carry out your wishes with regard to your health care. Not all children will agree on pulling the plug on mom. And I've seen this many, many times. And of course, there's a whole scenario of what that entails. The books sort of make it think like all you do is just flip a switch off and the person goes. Well, that's very rare that is the case. Usually the case is you have to remove life support treatment such as hydration and nutrition. And the doctors will tell you, depending on the size of the individual and the health of the individual, a person can live a long time without food, but they can only live in 7 days without water. So then we got a 7-day period where we're waiting for this person to die. Well, for some children, that is not appealing. And so as a result, they're vehemently opposed to terminating life support. Others say they'll do it. So you don't want to put in there a person who will not honor your wishes. And never put more than one person, because we don't want a tie. And I've seen ties, and they're ugly. And they, again, involve a lot of conflict, much of the time being resolved by courts. So you want one person. If you have to have more than one, maybe three, and that way there's not a tie. But in any event, pick a person who you can express your wishes to, and you know they will follow them. And now something that pertains to all of the documents as well is who do you share them with? We generally recommend, or I generally recommended, that you don't share them with anybody, other than a few exceptions. Your power of attorney for health care has to be an original in the hands of the person you're designating as your agent. I always did that document in 2 originals. I kept 1 original and gave 1 original to the client to give to their agent. That's because I don't want to get called at 1 in the morning saying so-and-so's in the hospital, I need the original of my power of attorney for health care. They've got it. And if they say, I can't find it, I've got it. Back then I couldn't do things like text or email things, but I can say I can provide it, and then you'll have it available to you. So in looking at that, you want to make sure that those documents are available should you need it. And with the health care, this, as I say, is a unique person. They don't have to have any financial abilities. They don't have to do a lot of work. They just have to be in a position of making medical decisions for you. But in that same regard, if a person, for example, a single person, becomes ill and has to go into the hospital and is not really what we'll say the person is basically incompetent, who is going to sign them in? They need somebody to sign them in. They need somebody to sign on the dotted line who's going to pay the bill. That's where your agents come into play. Your power of attorney for health care will allow you to sign them in and start caring for them. Your durable power of attorney for asset management is the person who can give authority to spend money because they can contract on your behalf. So again, there's things to get around all of those, but they're very costly and time-consuming and very upsetting to the family and having to deal with those issues. Now, you might say, well, what is the importance of a trust? Well, there's 2 basic things that are involved here. One is what happens to your assets when you die. The trust provides for the disposition of those assets. Those are the assets that are owned by the trust. A term is called funding when we put assets in the trust. For example, your house or your brokerage account, your bank account. We do not put cars, boats, or other such liability-ridden assets into the trust. Those are kept separate. But those assets then are subject to the terms of the trust. So that's one of the major factors that we have trust. And why do we do that? Because California has probably the country's, I won't say worst, but most expensive probate fees in the country. Not only that, a probate average, of course during COVID I found it was about 2 years, but normally it's about 1.5 years before we can distribute the estate. So it's a very protracted thing. There's a 6-month waiting period. So, I mean, you lost 6 months, right? And that's assuming you filed the day the person dies, which doesn't happen. But in any event, it's a very protracted proceeding. And the fees are what we call statutory. They're set by the California legislature. I've not looked at the adjusted fees. They have a cost of living adjustment. But when I was practicing on a $1 million estate, which back then was quite a bit, but today it's not because of the cost of the value of our homes here in California. $1 million, the attorney's fees are $23,000, and the executor's fees are $23,000, $46,000 for the probate. On top of that, there's probably $1,000 to $2,000 in court costs, appraiser's fees, expert fees, and related costs for notification. So you're looking at almost $50,000 to probate a $1 million estate. On a $200,000 estate, the fees are about $7,000 each, which is $14,000. You still have basically the same cost of a few $1,000s. But the importance is you want to avoid that, and that's why trusts are popular in California. You go to other states and they don't know what you're talking about when you say trust. And when I first started doing trusts some 30 years ago, you would go back east with a creditor or with an institution and say that this is in a trust. They go, what are you talking about? And they had no knowledge or idea of what you were talking about. But now, of course, I think it's pretty well known throughout the United States what trusts are and how they work. But the important thing to realize is that transferring of assets is not a simple process, given the best, and that is when you have a document that sets them forth. But when you don't have that, it becomes a nightmare. And the other thing that a trust does, which is, here we go, incompetency. What happens if you and your wife are co-trustees and both of you are involved in an automobile accident, for example, and you're not competent for a month or 2 or maybe 3? Who handles paying the bills? Who talks to the creditors? Who signs the tax returns if you happen to be in tax season? Who deals with basically the expense of the home and caring for the home during this period of time. Again, if you have powers of attorney for asset management and a springing power of attorney for health care, those help to a certain extent, but not the full coverage of all of your assets and your needs. So the trust does that. The trust says, and this is a springing thing within the trust. It springs into effect if you become incompetent and says that, your co-trustee or your successor trustee now can handle your affairs. And that's on a temporary basis, unless you're permanently diagnosed as being incompetent, which is somewhat rare, but it happens. And so the trust provides a mechanism for somebody to handle your affairs. And I would have clients say, well, I don't have anything. I said, well, I have $100,000 in a bank account, but I put my daughter's name on it. Well, then red flags come up, because you do realize that your daughter's creditors now have access to your bank account because it's a joint account. And you do realize that, yes, upon your passing, it will go to her. But then you have to deal with the creditors. Who's going to pay the creditors if all the money has gone out of your estate to her? But that's a whole other issue. But the point is, by having the trust, you are able to have somebody handle your affairs. Again, a husband and wife, I always made the husband and wife co-trustees, and then I put a little kicker in there, which some attorneys don't. I says, either one of them can act alone. Because if you don't put that in, then you've got a co-trustee who's incompetent. And every time you go to do something, you have to show whoever you're working with that the other trustee is incompetent. And that requires legal and medical documentation. So we put that in there. I also put in all my trust that the acting trustee has the ability to name a successor trustee. And that's very important, because just because you name somebody a trustee and they say yes today, tomorrow they may say no. Or in the future, they may not be able to say yes or no. So it's important to have somebody that can name somebody as a successor trustee if they do not wish to act. And I personally have been named as trustee, and I've said, no, I'm sorry, I can't do that. And fortunately, the acting trustees, we were able to then designate somebody else to do it. And there are professionals that do that. When Scott talked about my being a fiduciary, that's what I do. But I do a fiduciary from the standpoint of the financial affairs, not from the personal affairs. So as Patty can attest, for years, I did take care of people personally. Most of them were little old ladies who I became very, very attached to. And I would move them from nursing home to nursing home when they would come to me and say, we think Mrs. So-and-so would be happy somewhere else, which was the word, like, get her out of here, And so, but from time to time, I cared for these women. They've all now passed, and I have no one left that I know of that I would be taking care of personally. But I do handle large financial trusts and manage the monies. And that's my expertise, if you will. My degrees are in finance and economics, and basically working with what I used to call stockbrokers. They don't like that word anymore, but in dealing with them, that is my forte. And I like doing it because what I'm investing for, because all my clients are old, is not for growth. We don't care about growth because we're not going to be around for growth. So basically, I'm investing for income. And so it's finding income investments that will generate income for the individual to live on during their lifetime. Now, if their estate is so big that they don't need all of it for income, then we can get involved in growth things that we can pass on to the children. But usually growth things go up and they go down, whereas income things pretty much stay the same. It was lovely when we had United States Treasuries at 5-6%. That was such a safe way of investing money and just generating a nice income. Well, we don't have that now, so we have to look for other mechanisms in which to place funds that are protected but generate a good, sound income. So let's see what we got next year. What types of trusts are there? Well, there's generally 3 types of trust. About 90% of the trusts are what we call family trusts. This is usually a husband and a wife or a single person setting up their own trust, which means they're what we call the settlor. It's a weird name. In fact, when you type in settler on a document, Google will tell you there's no such word. It doesn't like that word, but it does exist. And the settlor is a person who creates the trust. And then we have what's called a trustee. And the trustee generally is the person who's setting up the trust because they're alive. So they will be the trustee of their trust as long as they can, either until they die or they become incompetent. And then, of course, I think we all know who beneficiaries are. They're persons who are going to receive the benefit of the trust assets once there is death. So that's what we call a family trust. There's what's called a special needs trust. Now, this is a very important trust. And this is, I haven't really hammered on the will and trust bills, but there are companies out there on the internet and in the community that will sell you will and trust packages, which create problems. I probably made more money, so to speak, off of dealing with those clients than I did my regular clients because I had to undo all of the problems that existed in these documents. When you have a will mill, if you will, or a trust mill, they don't ask you questions. They ask certain questions, but they don't ask all of the questions. And for example, I had a client who said, I went on the internet, I did an A trust, just a simple trust, because we don't have anything. Well, they did, but he just didn't know it. The question I always ask is, are you expecting any inheritance? And basically he said, well, yeah, my parents are extremely wealthy. So I said, well, how much? He says, maybe $7-8 million. I said, what? So basically what happens is within 2 years of him dying, he inherits $8 million and dies and has a single trust. He just gave up an exemption of basically however many million it was at that time. Right now it's $6 million. But the whole thing would have almost been exempt because it's his separate property. But that was all lost because nobody asked the question of, do you have any other expectancies? Or people that come in and have 3 or 4 children, and I'll ask them about the children, the health of the children, any problems with the children, how old are the children, and many times I'll discover that one of them is on disability. If you give a beneficiary a large sum of money, or you only have to give it to them if they're entitled to it, they are disqualified from getting their disability benefits, which can be a big, big problem. So it's important to make sure that you have the answers to those questions. Another kind of trust we have is what's maybe a special, not a special needs trust, but a special trust. And that's a trust you set up for usually just one purpose. So I'm going to Europe, let's say, and I've got a house in escrow and I want to sell it and I'm not going to be here. Of course, today, with the electronics we have, you probably could do that. But when I was practicing, you couldn't. And you had to have somebody that actually signed documents and not over the internet. They had to come in and sign documents and they had to be notarized in the whole thing. So again, you have a situation where that is extremely important situation where somebody has to have authority. Well, you give them a general power of attorney to negotiate and handle this sale. Just that, nothing else. And of course, once it's done, they're done. So that's an important thing. Now, there's sort of a caveat here. I had 2 situations. One was a Mexican client who basically came from Mexico and wanted to set up a trust for his 4 children and buy 5 units at Coronado Cay's, the condominiums. You know, when those things first came out, they were $50,000 a piece. So he buys 5 of them and puts them in the children's name in a trust. And it's an irrevocable trust. And then he decides he wants to sell them, and he comes to me because he says, they won't list them. They won't take my listing to sell these properties. Well, that's because they're not in his name. They don't belong to him. They belong to the kids. So I said, we're going to have to go to court and get permission from the court. And I said, not only that, the court's going to manage their money for the rest of their, well, until they turn 18. It's going to manage their money. You're not going to get it. You don't have access. It's not yours. He was just flabbergasted. Again, a plan that had gone awry. But it's important that when you do things, you understand what it is you're doing. And of course, he didn't. So you want to make sure that in your trust, it's set up in the proper way. And if it's a special trust, that it's going to accomplish what you want. I had another client, delightful man who was very, very well off. And he decided it would be a good thing. I didn't do this because if I had been involved, I would tell him, don't do this. But he sets up an irrevocable trust for his 2 sons and places a very large skyscraper in it in Los Angeles. two great young sons who I met. Unfortunately, his oldest son, who was a senior at UCLA, became schizophrenic. And that was a disaster because, of course, he immediately was on disability, receiving disability benefits. The trust wouldn't pay him any money until he reaches a certain age, which was like 25. So that wasn't a problem. But the problem was going to be as soon as he reached 25, all of his state and federal disability benefits would go away, and he'd be completely dependent upon the trust. So what we did was I came up with the idea of, well, I'll notify the state of California. And knowing the state of California, they'll never appear, which they didn't. I notified them that we're going to change this trust to a special needs trust within his regular trust that he had set up. And so we petitioned the court to do that, and the court granted it. And so now we had a special needs trust within the trust that took care of this particular son, so he still was able to get his benefits. So what a special needs trust does is basically supplement the disability benefits to the extent that it can. So in the old days, it was kind of a joke because when you would say, well, what are the excess things? Oh, like a vacation, or like having the dog washed, or, these stupid things which really were not. But nowadays, they're much more liberal in allowing the trust to provide for a higher standard of living. So, for example, you could buy a home in the name of the trust, and the person could live in that home. There's different things that can be done. So those are the three sort of basic types of trust. The other thing that the trust does is, as I said, restricts your gifts. So again, rather than giving an 18-year-old $1 million, you can basically do things like give them half at 25 and the balance at 30. How am I doing on time here? Okay. So you can basically do that and have them take the gift subject to those. I got to move because I'm eating into my time. That's not good. Okay, so let's skip over now to the power of attorney for asset management. I've talked about this before. This is a document which allows you to handle the financial affairs of somebody if they're unable to do so. It springs into effect. You know what it is in selecting the person that runs that, and you know the importance of having that document. You know the liabilities associated with that document and how to use it. And finally is the durable power attorney for healthcare, and we've talked about that. And again, you know the importance of that. It's a springing power, too. It springs into effect when you become incompetent, and then it allows your agent to handle your affairs. So I better stop. Basically, we've talked about organizing your documents and the importance of having legal counsel, and the importance of having a trust, the importance of having a will, and the importance of having your powers of attorney. So I hope I've given you some useful information and not overwhelmed you. And let's put in place, how have you put in place an effective estate plan and care for you and your loved ones. Thank you. I'm sorry. That's all right. If we don't get in all the questions, we're going to have this afternoon as well. So are there any questions?
Okay, we're going to go around with the mic so everybody can hear the questions. Thank you, Ken. So much information, so valuable. As we do this, I want to let you know we're going to have after every speaker, we'll have about a 15, 20-minute Q&A, depending upon the necessity for it. Then at the end of the day, we're going to have all three speakers up on a panel to wrap up with any other further questions that we might have missed or you might have thought of later. Okay? So first question.
Ken, what is the difference between a durable power of attorney, a general power of attorney, and a health care directive?
Well, the healthcare you can have a healthcare directive independent of your durable power attorney for healthcare. I put those directions in the durable power attorney for healthcare. I do not. In the old days, they used to specify procedures. Yeah, I want, this removed and this removed, but I don't want this removed. That's a disaster. And so what we put is, if my life were devoid of any means of understanding and appreciating my life existence, I do not want to be kept alive. And that's a very broad terminology, which allows to effectively carry that out. But you could have separately over here a directive to physicians saying, this is what I want and what I don't want. And you could have the two as long as they're compatible. So that's fine. The other question was regard to the difference between the special trust and our durable power of attorney. A durable power of attorney means that it goes on, it lasts. It only can terminate when the principal who creates it terminates it. And basically, it is usually a springing power until they get to the point where we then go with a durable power of attorney, which doesn't spring. It simply says it's immediate. And so that's the difference between those two documents.
Next question. Do you have one over there? Oh, okay. I'm coming, Jim.
So if you have an asset, just hypothetically a big IRA, and you have a trust, is it better to have the IRA have a pay on death, or is it better to make the trust the beneficiary of that asset?
That is a good question, and I've struggled with that question before because, as you know, IRAs have beneficiaries.
Right.
So they're not part of your trust. They will go to whoever the beneficiary is on the IRA, but you can name your trust as the IRA. This is where taxes come into play. And so it is important before making that decision you talk with a tax specialist that tells you what you're doing tax-wise. Because if there is a way to structure your trust to take in an IRA and pay it out to your beneficiaries as long as they're like your children or your spouse. But if you start getting to somebody else, like an institution, you got all kinds of tax issues. So it's important to address that issue, you know. And of course, the problem you have with an IRA is usually you can't put conditions on it. So I've not tried this, but I guess you could tell the holder of the IRA, the bank, that I want it to go to my children, but to be held until they reach a certain age. I don't know if they would do that or not, but usually you can't. And as a result, they would get that IRA. And then, as you know, one of the problems we're dealing with here are what ifs. And one of the big what ifs is Congress, because they change things all the time. And we never know what they're going to do. And right now, there's a tremendous disadvantage on transferring our IRAs to our children. We used to be able to do it, and they would just pick up their age and spread the benefits over. Now it's 10 years. So within 10 years, you have to take it all out, which means you could take a little each year, or you can take it all in 10 years. So that's one of the problems you run into when you put it into the trust, how long you can keep it there. But yeah, I've seen that done, where it's been put into a trust, and then the trust provides that the IRA benefits will be held and distributed in such a way. So it can be done, but it's very tricky.
Ken, one of the things when we were meeting, all of us ahead of time, that you had mentioned before you're next, was your healthcare directive. And one of the things you said, which I thought was really practical advice, is when you have those, or if you have those, make sure your doctor's office has a copy of that, and the hospital that you would go to has a copy of that already ahead of time. Correct?
Right.
Did I hear that correct? I thought that was very tangible advice.
As I said, in sharing these documents, we don't usually share them except to the extent the medical power of attorney.
Yes.
You give the original to your agent. Your doctor should have a copy in his file, and the hospital you regularly go to should have it. If you've been a patient at a hospital, they will take it. You can't just walk into a hospital where you're not a patient and say, here, take this, because they have no place to put it. But if you go to Scripps or you go to UCSD, they can have it. And nowadays, you can put things on your phone, and so you can actually put a document like that on your phone and be able to show it.
Have that available. I thought that was very tangible advice. You good? Anybody else? Elaine and then Jim.
I've been told you can avoid a trust by having a payable on death account or a joint account. Are there any problems with that?
No, as long as you don't want any restrictions to go along with it. In other words, if you have no problem with the person getting the money immediately, and if the account's in just your name, is that what it is? Not a trust, it's just in your name? No, it's in a trust? Okay. The problem with that, again, is without a power of attorney for asset management, if you should become ill and we need to get those monies to pay your bills, we can, without going to court. There's always a way of doing things. And that you go to court for instructions. But that costs thousands of dollars and takes time.
Ken, maybe on the opposite end of the spectrum, if you could talk a minute about the complexities of like an online stock trading account.
A what?
Like a TD Ameritrade or a Schwab online account where it's only a username and password to get to the money.
Well, funny you should ask that question. The account should be in the name of the trust. You can put that account in the name of a trust. But I had a gentleman come in, $1 million estate. They had an elaborate estate trust plan, which I put together. He comes in 3 weeks after she dies and says, Ken, I just found out my wife had a brokerage account at such and such an institution, which I knew nothing about. I said, oh, how much is in it? He says, $150,000. I thought, oh, because there is a small estate exemption of $100,000. It's the cost of living index, so it's higher now, which will allow you with an affidavit to transfer it. That's how we transfer cars and boats and airplanes, assuming they're not over 100,000, into the name of somebody else. You just take your will that says you're the executor. I don't go to the DMV, I go to the Automobile Club. You go to the Automobile Club, and with a matter of minutes, they will transfer title using your power as an executor to whoever you're selling it to. But going back to your question, this gentleman came in and said, he found this account. I said, well, did your wife have an online account? And he says, I don't know. I says, well, let's see. So I got on the computer and boom, no account. I says, well, let's create one. So we recreated an account for her. And I said, okay, now she has an account. Now what do we do? I said, let's withdraw half of it and see what happens. So we withdrew half of it. And 2 weeks later, a check came to the house for half the account in her name. And of course, he has a joint account with her. Her name's on the account. Boom, he deposits the check. And says, that worked. Let's get the other half. And that solved that problem. That saved that gentleman probably about $20,000 in a year and a half of his time in dealing with it.
So if someone already has the account.
So that might not be totally legal, but it definitely is equitable. It's definitely equitable. So if we went to a court of equity, the judge would say, good show. But we didn't have to go there. There was nobody else. Yeah.
So it would be important to know of your parents or your children or spouses, maybe have a list of any accounts with usernames and passwords. Is there, if there already is a username and password, because I don't know if your question was answered, Jim. Okay.
Passwords are, I don't know if that's part of your question, passwords are a whole different issue where you have to make sure somebody's aware of where they are.
Back here.
Quick question with the special needs trust. So if somebody with a disability or special, they want to set that up, if they receive, it's the person that has the disability that would want to have a special needs trust set up. So if they receive an inheritance or something, their insurance and their disability doesn't disappear. Do I understand that correctly?
Yes, if there's a
Okay.
special needs trust.
Right.
In the trust, it specifically says that nothing will be distributed to the beneficiary that would in any way limit, affect, or diminish their benefits.
Gotcha. So
Okay, so that language is in there. So whatever the law is at that time, that dictates what they can and can't do.
and the person that would, so you'd have an executor or something like that that would run your.
They'll have a trustee.
The trustee,
Yeah.
and then they would make
It's
the decisions on how
sometimes
that
people
financial.
Sometimes people will put in a special trustee, which is what they did in this case.
Gotcha.
The father named the brother as the special needs trust. But the overall trust still had dad as long as he was alive. And then basically the brother took over as trustee when he died. But before he died, basically the son became the trustee. So he also was the trustee of the trust and of the special needs trust.
Thank you.
More questions? Linda?
Back to Elaine's question of if it's not in a trust, but you have designated beneficiaries, why, if you're still alive but incapacitated, if you have somebody taking care of you, would they not be able to use that money?
What, I don't understand the question.
Well, Elaine's question was, is it okay to have your money not in a trust, but just with designated beneficiaries? So, a joint account, but then also you could have a designated beneficiary. And you said if you became incapacitated without the trust, you wouldn't be able to use that money. Why?
Well, the individual, if they become incapacitated, they can use the money, but they have to have somebody acting as trustee to give it to them. So that's where the successor trustees come in to do that.
Would it need to be a trustee, or could it be part of your
No,
medical power of attorney?
anything that's owned by a trust, only the trustee can deal with.
But that's why, but that was no trust.
What?
But her question was, if you have no trust,
If you have no trust,
the
if
money
you don't
is,
have any documents,
well, you would have documents.
do you have a will naming somebody as executor?
Okay,
Do you have a power of attorney naming somebody asset management?
okay. So if you have all the other things, you don't have to have a trust to have your money still be.
Well, you don't have, no, you, like I say, everybody's dynamics are different. You don't have to have a trust as long as you have a backup plan to deal with death and incompetency,
Okay.
okay? But there's other reasons for having the trust. I mean, that,
Hello, hi. I have a question about changing in capacity to make medical decisions after someone has already set up everything ideally. How can they be protected when estranged children may come challenge the things that we would have ideally set up?
yeah, that's a big concern. And I find that wives are more concerned about that than husbands. And so one client, a dear friend of mine who was a member of our church, she invented what I now call the bimbo clause. And her biggest fear was because of all this money, her husband is going to go out and get taken by a bimbo, and she's going to take all the money. So I call it the bimbo clause, but you can provide for that. Now, the way that you provide for that is interesting, and we have actually in our trust. So Patty's protected from me getting taken advantage of by somebody, not necessarily a bimbo, but I've seen health care, people coming and taking care of houses, take over estates and stuff. But it works both ways. But we have a trust that says before there can be any changes to the trust, there has to be consent from our two children. So anything that's going to be done has to be, once one of us is gone, it has to be run by our two children, and they have to sign off. That has a technical name. I never used that when I practiced because it didn't exist, but it does now. And Kelly, my daughter, put that in our trust, and I don't recall the name of it, but it's a nifty little clause. But yeah, I had caregivers that came in, took care of this client's son. This client was a client of mine for a long, long time. His home was in his trust. The rest of it all went to charity, and the son was living in the home, and he actually was disabled to a certain extent. And a group of caretakers actually moved in, everything, all their stuff, and they lived there with him and cared for him. And they were very good to him. And they had him do a will, leaving the house to them. And so when he died, they showed up at my door saying, "We're here to get the house." I said, "Well, the bad news is the house didn't belong to him. It was in his father's trust, and it goes to charity." Never saw those people again. But I mean, that can happen.
Okay. Ken, this has been a fire hose worth of information coming at us. Is this, most of this included in the 25 things that you first started with, as you know, the handout?
Yeah, we'll put it on the table right there.
Okay.
Yeah. I'm sorry?
Yeah. Okay. Yeah. Are all of the topics at least identified in the 25 list, the page list of 25 things you need to do?
Well, I think they identify. I read it the other night just to make sure it didn't say something I didn't like, which I didn't see that. I wasn't focused on that particular question, but I think it talks about just your powers of attorney for health care. There's just the four things you have to remember: trust, will, power of attorney for health care, and another power of attorney for asset management. So you can call a power of attorney for health, power of attorney for money, trust, and a will. Those are the four things. Okay,
the other thing is the charitable remainder. Is that just a subsection of the trust, and how is that? You haven't mentioned that.
That is a tax question, and how we minimize estate taxes through charitable remainder trusts. You can have a charitable remainder trust within a trust. We don't generally recommend that. We generally recommend a separate trust with the institution, the charitable remainder trust. But you could do that. I've not seen it done because then what happens is you're sharing your whole estate plan with whatever the charity is. So they will get whenever somebody's named as a beneficiary in a trust, they get the document. And so these clients have said, I want to leave 1% here, 2% here, 1% here. I'd say, whoa, wait a minute. You do realize that I have to personally notify each one of those. I have to wait 120 days from them being notified before I can do anything. And basically that means I'm sending out all these letters at the rate of maybe $1,000 a letter to all these beneficiaries. Plus, if they put in 1%, it's 1% of what? It's 1% of the corpus of the trust. Well, if it's 1% of the corpus of the trust, am I a beneficiary? How did you get my 1%? What did you spend all that money on? I want an accounting. They're all entitled to a full accounting. And any one of them can take you to court and say, you account, because I think my 1% of 10,000 should be 1% of 100,000. So percentages I don't like. I would always say, convert it to cash. As a percentage of your estate, convert it to cash and give them 100,000. Those checks are easy to write. Right off the top, boom, they're gone. But in any event, yeah.
Thank you.